That's still very specific. That's fair.
Qualified bands. Living supply. It's like a big cultural war going on online. Sorry.
Yeah. Sure. Like, how are you? Where's the problem? Butler County. Yeah, that makes sense. I argue that everyone should suck up funding from other counties and they're not. So it includes.
We're not.
Yes.
What is the definition?
Well, it's just it's started in Cincinnati. I mean, it has been that way since. I used to go out there all the time and I lived in Cincinnati. So I mean, that's.
Of course, in fairness, at that time, it was probably all.
Well, what it was is I can remember.
I'm not sure.
Walker was
Observing. Okay.
Yeah.
Just want to make sure.
Thanks, Chris.
You're welcome.
I go out, and so I was constantly going to Pavia, up there in Port Valley. Literally the only thing that was out there at 275 and 32. No. The only thing out there was the Holiday Inn next to the East End. That's it. That's the mall. Yes, it is. Yes, it is. So that's how I can date myself. That's all I can remember driving out there. My in-laws.
Has been 5 years.
The last one,
Yeah.
was,
It was 5 years ago. Well, I mean, the last time I was down there, I was down there repeatedly when my father was passed. And I never think like 32, I would go down and say, I think I was there. Oh, really?
I mean,
Wow.
same.
Yeah.
Together, yeah.
honestly,
Oh, did you go to?
I did, I was telling you about. Yeah.
Is everybody signed in that wants to sign in?
Thank you, Director.
No problems. I just need.
Okay. Well, better here.
Okay.
Okay, I think that's really bad.
Yes.
Doing the same.
And these are all, all 30. She's here. She was. But those are the only people close to us. So I just, let's just go through. Unfortunately, what we didn't do. Living in the school. They want us to be thinking, we cannot, we just do them. And they all know that I think we're no violation.
Okay, excellent.
Are you stealing my money? What do you think?
No, I have two sides.
I gave you the basic agenda, which was nice. The reason why I gave you the basic agenda, because I had to update it, because when I sent up a week ago, was Mr. Loudon still included the case that we have with Mr. Yes. What do you think? Finally, but we'll deal with it in the next meeting.
Okay. Right.
I hate to.
Okay, calling to order the July 25th meeting of the Ohio Elections Commission. Bill, do you want to start with?
I will do it. I certainly will. Mr. Caraway, Mr. Kirchner,
Present.
Ms. Davis,
President.
Mr. Knight,
Here.
Mr. Lyle, present. Meeting Chair and Vice Chair Hagan.
I'm only fulfilling my role. Present.
You still do both. Ms. Tavares is traveling, as is Mr. Cole. And so that's why neither one of them are here today.
Do we have a motion to exclude them for their abstention. Or excuse me.
So,
Second.
All in favor, signify by saying aye. Any opposed? Seeing none, that motion passes 7-0 to exclude her. I apologize, excuse those two members.
It's fine, thank you.
Moving forward, are there any questions or recommendations and review of the minutes? For any motions?
For what I, just for informational purposes, for what I sent out last Thursday, there was one minor little error, and then I was giving Mr. Kirschner an indication that he was absent from the meeting when it was actually Mr. Caraway, so I had to make that change. It was in the first reading paragraph. So that has been changed. Other than that, I think the minutes are appropriate review.
Only my name is misspelled, first paragraph. I don't want to be that person. But,
then now you officially are.
but this you have, sorry.
I'd like to move to amend the spelling of your name.
No, rather not.
Somebody else.
After a roll call, all members of the commission were present, with the exception of members that they Caraway was a being, not a being person.
Tomato,
Okay.
tomato lines.
I'm sorry.
My mother's the only one that cares, really.
I think your son does too.
Great.
She's not gonna read these minutes. Why are we wasting the state's time?
Trying to not only the family's last name, but also first names. All right.
That's fair.
Very good.
Fair.
All right, well, we will see that that is corrected.
Yes, that's.
Very good.
So,
Is there a second?
for the minutes.
Second.
Thank you, kindly gentlemen. All right, very good. All in favor signify by saying aye.
Aye.
All opposed?
Thank you.
Seeing none, that motion to amend and approve. The minutes are reapproving.
We're
All right, we are good to go.
approved.
Okay, moving on. The first group consideration under group recommendations will be dismissals. Obviously, case number 2024R-346 and 2024R-351.
Yeah, I'm recommending a simple dismissal only because we dealt with these previously and obviously we did not sufficiently notify Lucas County Board of Elections of our findings because we declared both committees terminated at a prior meeting. I apologize for that. I will make sure that gets taken care of in contacting them. Meisinger, we terminated his committee earlier because the board indicated to us that he had moved out of the country. And at a May meeting, I think it was, Ms. Tinta requested reconsideration. And so we reconsidered her case, as part of that reconsideration, declared her committee terminated based on the request. So I'm recommending the dismissal and that would take an action. I would request an action by the commission.
Are there any questions of the executive director or any dialogue that you'd like to have? Hearing none, are there any motions?
So,
Can we get a second? Sorry, very good. All right, that has been motion and seconded.
Thank
Are there, all in favor signify by saying aye.
Aye.
Aye, any opposed? Hearing none, that motion carries for both of those cases. Thank you. Moving on to the no violation category, the executive director has informed me that we do have two parties interested to item number 26 and 27, Peacock Water et al., and also Marion Technical College et al. After the executive director addresses these, would either of those parties' representation like to say anything today?
Briefly, on behalf of Marion Technical
Okay,
Vice Chair.
do you have any desire today?
Thank you. I do represent Peacock Water. We don't intend to belabor the point with regard to the knowingly aspect, but happy to answer any questions should they arise. Thank you very much.
Very good, okay.
Yeah.
Kelly, I apologize.
No, that's fine. You're doing fine. Yeah, I'm recommending no violation on these matters. It may seem strange, but the point was made in the submission by counsel for Marion Tech, Mr. McDonald. McDonald, who you presumably wants to speak to the commission. If you were to actually see the referral form, when the Marion County Board of Elections sent the referral down here, it made reference to revised code section 351713, the obligation to file the 30B1 form, which is what these are, is in revised code section 3599.3, and that was not included in the referral. What we have here is a corporation is obligated to file what's called a 30B1 form when they make a contribution to a ballot issue committee. And these organizations made contributions to a Marion County Developmental Disabilities PAC and did not file the 30B1 form and that they were obligated to file. All the filings have been made because we got responses from everybody on the list. I was heading toward good causing these until I read Mr. McDonald's submission on his client's behalf. And so if I was going to dismiss that case for that reason, I didn't feel it would be fair to make a different finding for all the rest of the organizations that are included therein. And just while we're dealing with this category, even though it's not included, item number 32 is not included in the, even though it happens to be sequentially the next one. I'll speak to that briefly. The candidate there is currently a common pleas judge in Butler County, and who is running for an appeals court seat. The Butler County Appeals Court is a multi-county jurisdiction, and so when she runs that way, when she runs for that position, she's obligated to file with the Secretary of State's office. And the even in their referral, Butler County indicated that she timely filed a report with Butler County, but she needs to file with Secretary of State's office, which at the time she hadn't done. Subsequently, she indicated she has done. Potentially, that might mean that we might get a late filing referral from the Secretary's office, but everything's fine with regard to Butler County. And so that's why I'm recommending no violation as it relates to that case. So anyway, Mr. McDonald would like to address the commission. Certainly, the commission would like to hear from him. We can certainly hear from him.
Thank you. Thank you, and good morning. On behalf of the respondent, Marion Technical College, Matt McDonald from the law firm of Dickinson Wright, PLLC, Vice Chair Hagan, and commission members, as Executive Director Richter noted, our motion to dismiss basically states that there was no violation here of revised code section 351713. Marion Tech is a registered nonprofit corporation in the state of Ohio, and the complaint fails to plead a violation of Ohio election law, and it fails to meet the commission's rules that establish sufficiency requirements for complaints. Revised code section 351713E imposes a requirement that no person other than a campaign committee shall knowingly fail to file a statement required under sections 351710 or 3517.1.107. 3517.10 sets forth the timelines required for every campaign committee, political action committee, legislative campaign fund, political party, and political contributing entity to file reports. But the college is not any of these aforestated entities, so this statute doesn't apply to the college. Similarly, revised code section 3517.107 requires federal political committees to register and file reports with the Ohio Secretary of State when engaging in Ohio-specific activity. Here, the college is not a federal political committee. Therefore, we respectfully ask the commission that find that no violation has occurred. Thank you very much.
Questions?
Thank you, Vice Chair.
We can handle them all together. Having a motion to either approve, if the commission is prepared to approve my recommendation, let's put it that way. Obviously, I'd answer the questions the commission may have.
Mr. Richter, so it's like items 24 through 31. Obviously, we just heard about the 27 and is represented in 26 here. Were these all referrals from the same, these are all Marion County, right?
24 through 31 were from Marion County.
Okay,
32 is from Butler County.
okay. Requirement, just so I understand, the 30B1 form, is that to be filed with online with Secretary of State or paper copy with the local board of elections?
You have an obligation to file, essentially you have an obligation to file it at the same time as the report in which the contribution is reflected for the ballot issue committee. So if these folks made ballot issue committee contribution, I can't remember when, but let's say they made it last summer and the PAC filed a pre-election report, that's when the 30B1 is obligated to be filed under statutory scheme. And that's what was not done. I don't know whether it was a pre or a post-election filing, or even an annual for that matter. But you filed 30B1 at the same time as the contribution is reflected on the ballot issue committee's campaign finance report. Or at least that's the deadline. You can always file it early. And I've had this, I've said to other people, the old commission, which you'll hear me refer to every now and then, did not have jurisdiction over the statute. And when the commission got jurisdiction in 1996, we had a slew of 30B1 violations submitted to us because previously the only way the statute was enforced was if a prosecutor decided to do something in the respective counties. And when it became to us, all of a sudden, people were aware they had filed 30B1 they didn't know of before. And so for the first, 5 years, 10 years of the commission, especially early on, we got a lot of 30B1 referrals. I probably haven't seen a 30B1 referral like these in 10 years at least, if not 15 years. And then we have all these here. Whenever I get an opportunity to present to a group, like I did on Tuesday, I will say one thing a board can do to help the situation is if the treasurer for ballot issue committee comes in and discusses it, and you say, hey, if you get any contribution to the corporation, you might want to make sure you're getting 31 form for that corporation, because that way if the corporation makes a contribution and they get referred to us, they're not gonna be real happy. But if you pester them at 31 and file it at the same time you file your campaign finance report, they might make a contribution to you again in the future. So
the Board of Elections would have known about these entities that had donated because of the finance report.
Correct.
DD,
correct. Correct. As they're doing their audit of the campaign finance report from the MRDD group, all of a sudden they see all these, they did a double check to see if they got 30B1, it's not there. So I spent about 4 or 5 telephone calls with the treasurer of this committee, who was aghast, they can say, a couple phone calls with the staff at the Board of Elections, and then numerous calls from Mr. McDonald and Ms. Dainer, who's here as well on the committee, and I probably talked to 2 or 3 other people. So kept me on the phone for a while.
Are there any other questions of the commissioners? Okay, is there a motion?
Madam Chair, I'll move Executive Director's recommendation for cases 2024 R-322 through 330.
So including 330 in that same grouping.
Yes, ma'am.
Okay. Is there a second?
I'll second.
Very good. All in favor, signify by saying aye.
Aye.
All opposed? There are none. That motion passes 7-0. Do you want me to read these into the record or
No,
sufficient?
I think Mr. Lyle sufficiently identified the cases about which we're speaking, so I think that's okay.
Very good.
6-0.
I apologize. Thank you.
Yeah, 6-0.
You too. Thank you very much.
So
So
I'm good with the math.
correcting the record on the others, yes, thank you for counting up to 6. We appreciate that, Commissioner Knight.
It's up
Very-
to, up to
very
9, I'm
helpful.
good, you get double
I
digits.
I clearly was not equipped to do that, so thank you. So- All right, very good. Moving on to the good cause cases. Referring to cases 202R-190, -194, -306, -311, -336, and -337.
Yeah, you can see my little blurby explanation of the reason for the recommendation in matters. Some, it's the first time they've been referred to us, and they, both filed the report and filed the response. A couple of them, though, are second time before the commission, but I'm kind of giving a break, one for health reasons and one for the new treasurer, the breakdown of communication. I'll be glad to answer any other questions that you may have as it relates to this recommendation to find a violation, but for good cause not imposed fine. Or refer the matter for the prosecution.
Are there any questions of the executive director or for the cases in front of us? Seeing none, is there a motion?
So moved.
Thank you.
I'll second.
All right, seeing motion in a second, all in favor signify by saying aye.
Aye.
Aye, all right, any opposed? Seeing none, that motion passes 6-0. Thank you, Mr. Knight. Moving on to the next section, $50 fine category for cases 2024R-300, 305, 307, 318, 319, 332, 350.
That's it. These matters are ones where the report was filed, it was late, beyond about 2 weeks. Responses were submitted, they gave me an explanation. But my recommendation is to find violation of impose a fine of $50. I'll be glad to answer any questions.
Madam Chair, a question for the executive director. Mr. Executive Director, do they all have the same reasoning for why they submitted late?
No, I can go through and look at the ICWs, but you know, each one has their own little explanation for what occurred.
And with that, you still chose to implement 50?
Yep.
Okay, thank you.
Yeah. Pretty much if they just come up with some kind of an explanation, I'm willing to accept that. Unless it's something that's, I guess I might say more accusatory toward a commission or something along those lines. But as I've said to people over the years, you know, I've seen everything even to the dog ate at one time. So, give me an understanding of why you were late. I'll pretty much take it.
So moved.
Second.
Thank you. The motion is second. All in favor signify by saying aye. Any opposed? Seeing none, that motion passes 6-0. Moving on to,
Yeah, sir, you walked in late and you aren't listed. And is there a particular case you're interested in?
Yes, my name's Joel Campbell, and late by about 4 or 5 minutes because I couldn't get through the SCARE system here. But I'm here on the Washington Township levy. And I don't know that they told me at the elections office up on Morse Road that you didn't need to have to be here, but I just wanted to make sure that everybody understands that there wasn't any intentional act on anybody's behalf, and that we did get the filing done. It's been the same amount of money in Fifth Third Bank's hands since this began, the bond levy before that. It's about $3,000 and it sits there today as well.
Mr. Campbell, if you'd like to just approach, we'd love to
Oh, there.
just share with you each.
Just look at from the beginning, I
Yeah.
didn't see the middle. Okay.
Welcome and thank you for making the drive.
Well, I was lucky. I just live here in Dublin.
All right, very good. Well, we have already issued a decision on that case. Mr. Rector, would you like to speak to that?
Yeah. We found there was a violation of statute for lateness, but we found that there was good cause not to impose a fine or refer the matter for further prosecution. Because give me a second, and I can find my outline. 306. Yeah, you know, and honestly, the commission was accepting of my recommendation, but one of the bases for my recommendation was the fact that when you submitted your response, you indicate you served for over 20 years and not had a prior violation before the commission. Here's your first time, and so because in some regards, your submission was beyond about 10 days or 2 weeks, which is what is kind of a time frame for imposing a fine. but because you had served for so long for the committee and not had prior violations, I took that into consideration, made that recommendation, and the commission accepted it. So
Well,
just for your information.
thank you for your consideration, and I guess that takes care of it for me today.
And your name again?
Joel Campbell,
Okay.
Supreme
Okay.
Court number 0002421.
Okay. Thank you, Mr. Campbell.
Thank you all.
Thank
Have a
you.
good day.
Then moving on to the $100 fine category for cases 2024R-304-308-310, 310, 312, 313, 315, and 334.
Yeah, as I've indicated again, in the majority of these, it's the second time before the commission. For, excuse me, for case number 304, the report was filed, but there was no response submitted for me to give a different recommendation on $100 fine. So I'm recommending in all these matters that we find violation, impose a fine of $100.
Good. Is there any dialogue or any questions of the commissioners? Seeing none. Mr. Lyle, would you like to continue to lead? I count on you.
I see you clean stew.
Is there anyone else feeling like throwing motions today? Or is it just?
They have their coffee.
All right. Well, all right, very good. Having a motion and a second, all in favor signify by saying aye.
Aye.
Any opposed? Seeing none, that motion passes 6-0. Moving on to the $25 a day consideration option for cases 2024R-309, 321, 335, and 342.
These are matters that are before the commission for the first time. The report has not yet been filed. I double check with the Board of Elections in each case. And so my recommendation is to find violation and impose a fine of $25 per day, but giving them the option to have the matter reconsidered if the report is filed and a response is submitted. I'll be here to answer any questions of the commission.
Very good. Are there any questions of the commission or any motions?
So moved.
Second.
Oh, all right. Thank you very much, Mr. Lyle, Commissioner, giving Mr. Knight a break. All right. All in favor signify by saying aye. And any opposed? Seeing none opposed, that motion passes with 6-0. Moving on to the $25 a day with reconsideration option with payment of $250 category for case number 2024R-316.
This is the second time, excuse me, this candidate has been before the commission. The report has not yet been filed, and so my recommendation is to find a violation and impose a fine of $25 per day, giving the respondent the opportunity to have the matter reconsidered. If a report is filed and a payment of $250 is received by the commission.
Any questions or motions?
So moved.
I'll second.
Very good. With the motion by Mr. Lyle and the second by Mr. Kirschner. All in favor signify by saying aye.
Aye.
Any opposed? Hearing none, that motion passes 6-0. Moving on to the $4,400 plus $25 a day with reconsideration option for case number 2024R-317.
Third time for the Clark County Young Democrats to have come before the commission without having filed their report. Got a confirmation from the Clark County Board of Elections, and so my recommendation is to find a violation and impose a fine of $4,400, which reflects $25 a day from the date the annual report was due until today's meeting date, plus $25 a day with reconsideration to give them the opportunity to have the matter reconsidered if they file the report and submit a response.
Very good. Are there any questions?
Madam Vice Chair, are we getting service on this entity?
Check out the board meeting. So. Yeah, but we sent out, the certified mail came back, but then we sent out the regular mail, June 24th. And it did not come back as undelivered. So, for the timing of the mailing, we can consider them to have received the mailing. And so I'm prepared to go forward on them.
And any of the past times that they've been before the commission, have they acknowledged, I'm sorry, I don't have the ICF in front of me.
I don't, I could go back and look at prior matters, but I don't have that.
The initial one though said undeliverable. I see it here, right?
For today's, yeah, he was asking about previous
Second.
cases,
I'm just.
and I said I could go back and look.
Without looking,
But I haven't, I don't
right.
have those noted on.
Gotcha.
Generally, you have checked with Board of Elections to see if they have a good address, right?
Yeah, I mean, if, we'll certainly accept that what they give to us, and then send out materials, and so, if something has, I mean, if you look back at the, back in the 2021 case, they did file a report back in 2021. Didn't pay the fine back to us, and subsequently have filed it in report. Yes.
All right, any other questions or motions?
I will make a motion to accept the recommendation of Executive Director.
Very good. Is there a second? All right, very good. With a motion and a second, all in favor, signify by saying aye.
Aye.
All opposed, seeing none, that motion passes 6-0. For the next category, 17,600 plus 100 day with reconsideration option for cases 2024R-341 and 345.
Both out of Lucas County, I got a response back from the campaign finance person in Lucas County, those reports have not yet been filed, so my recommendation is to find a violation and impose a fine of 17,600 plus $100 per day, but give the respondents the opportunity to have the matter reconsidered if they file a report and submit a response.
Are there any questions? I do have one question, Mr. Richter, for these cases that are obviously looming and piling up financially, do we have that line in the sand for the accrual of dollars or time frame that we want to go ahead and push them on? I know that two gentlemen on the committee are itching to ask a question, so I thought.
There you go. Wasn't on me,
Mr. Oh, okay.
Madam, thank you for.
Yeah, I'd suggest maybe we consider addressing these particular matters, because we were going to address an update on AG collections and referrals, after regular business is over.
Okay, so just let business carry on as usual today, but then have that defined point in time moving forward.
That's what I mean, moment after we're done with regular business, I think we were going to go over the status of AG collections and any of that. Yeah.
Right, but are you wanting to refer either of these cases is the question I have, I think.
Well, to make the finding, we would eventually refer them.
Okay. Okay,
Let's put it that way.
very good. All right, thank you.
So moved.
Very good.
Second.
All right, Mr. Lyle and Ms. Davis, thank you for a motion and a second. All in favor signify by saying aye.
Aye.
All opposed? Hearing none opposed, that motion passes 6-0. The rest, I will go ahead and continue for service. Those are cases 2024R-301, 302, 303, 320, 331, 333, 338, 339, 340, 344, 347, 348, and 349. Absolutely. And then moving on to other business.
Madam Chair, if I could, I just had two items. One was transition. Our committee had been working with Mr. Richter on his plan, and then the second was the item that was referenced earlier at the last meeting. We asked Mr. Hughes to provide an update on two things. The first is the status of referrals, and the second was the AG's success, if any, on recoveries. But I know that as it relates to our committee that concern transition, Mr. Richter sent out a pretty detailed couple of emails. My line items, Bill, were recent developments, timeline, and budget. So if it's okay with the chair, just maybe provide a summary of our transition.
Just to bring everybody up to date, I did meet with the governor's person who is responsible for boards and commissions, Haley Donahue. We had a great conversation about a month ago at this point. Discussing, essentially my situation here. And certainly, I won't go around saying that they're, prepared to wholly endorse whatever I might, let's say, for the budget for this. They at least now have an understanding of what, what my plan is, and where I'm going. She indicated that, she indicated to me, they're very pleased with, or she is at least, with, what I've been doing, what I've done for the commission. I guess I'll almost see much of anything to keep it out of the papers, as much as possible, and keep things moving along. So I appreciate that greatly. She indicated that the governor's office is very interested in this position and seeing something, and that there's a very good possibility that they may bring someone forth that they may believe is appropriate to replace me. And I indicated to them that, we would certainly give that person strong consideration. Certainly didn't say, yes, that person will be approved. But I said, when it comes to time as we move this process forward. She didn't have anybody. She asked me if I had any names, and at this point, I don't, per se. It is something I've been thinking about. I shouldn't say totally I don't. I've got a person in mind, some other people I want to reach out to, but I haven't done anything as to that. So it was a good meeting, and their understanding of, kind of where we are and what's going on with this. I met with the appropriate staff at the Office of Management and Budget. They are, they understand too. They certainly weren't going to say, yeah, whatever you want is fine. Actually, they punted much more than the governor's office did. And I think it was either middle of last week. I will admit I haven't looked at anything yet. Middle of last week or earlier this week, I got notice from OBM that budget guidance has come out. And so that's something I'll be starting to look into next week. I anticipate bringing something to you guys, which will be a bit different for me, because like I said, I haven't presented a budget to the committee probably almost 20 years at this point. But I will, outline some things. We can discuss that. I'm not anticipating doing it at the next meeting, probably 29th. If they changed it, it might be earlier, but over the last 4 or 5 budget submissions, my obligation is to have the budget information in early to mid-October is when I have an obligation to submit that to OPM. So, there's time enough at this point. I talked with them about, putting something in for somebody potentially, I guess, work alongside with me either next year or the year after that. I also talked with them about, the possibility of updating some of our, Chris and I have talked with a group out of Cleveland that I know particularly, the Ethics Commission and what the Control Commission uses as a part of their electronic finding situation. And they've been very pleased with this group. And I got a bid from them on potentially installing something for us. And I've also talked with Representative Seitz's office about that, and they're interested in potentially putting something in to have, get that approved for the commission. But that wouldn't go until lame duck, go through. And I talked with the folks in budget about that. And what they encouraged was, go ahead and put that in your budget submission. And if it does happen to get approved in lame duck, they have no problem taking it out of our budget request. But that's something they would certainly consider as I did that. But I have not yet reached out. I was going to reach out to, and I'm not sure how well I would, who I would talk to or anything have to do with the leadership in the House and the Senate. But I was planning on doing that. I haven't done that yet because they're out officially, until after the election. But, you know, maybe I'll talk to a staff member or something like that. So that's kind of where it stands as it relates to transition, and budget for that matter.
That's great. Your institutional knowledge cannot be overstated. How long do you think it would take to mentor someone? Probably longer than you might think. I mean, there's gonna have to be some relatively significant overlap from my perspective. And there's no guarantee the first person works out, but hopefully they would. What are your thoughts on one, mentoring timeline, and two, the work product that you might have to put in place for that purpose? I think of a scenario where that first person doesn't work out. You've now been gone for some time. Do you have some materials that you think would be appropriate? Your timeline was, I think, summer of 26 in an email somewhere around that time period.
Right.
So the good news is we got a couple of years here.
Right.
What sort of work product do you think would make sense for you to prepare? And what do you think the mentoring timeline looks like?
You know, I mean, it's one of those things where actually going back there, I have saved all of my, you know, you're used to getting the ICWs and so forth and the working agendas. All of those, I don't want to say all of them, because there have been a couple of times, I'm sure, over the years where I've inadvertently saved one document over another, and don't have a few of them. But document wise, all those materials are there. And certainly, you know, it's easy enough, I think, to lay that out to somebody to say, hey, here are the ICRs. Here's how you go about preparing them, and here's what they produce, and here's how you know, here's how I have at least assessed cases. And so, and, you know, as I'm concluding, let's say, you know, all those materials, all those historical materials would be available.
I see that as a big challenge, though. You know, if you gave me a library and said, figure it out. Well, sometimes I think from like a standard operating procedure standpoint, there are some, I think, unless the commission disagrees, since we do have, you know, a couple of years here, maybe developing, I don't want to over document, but to have some standard operating procedures that talk about your approaches to things might be really helpful to both us and to someone that you'd be mentoring. Does anybody have any opposition to that, Bill or the commission?
I don't know, but I prepared got a document that kind of says, here's kind of the basic outlines that I use in terms of assessing cases and making recommendations.
Yeah.
You know, so I mean, I already have, I've had a version of that for a while, and I updated it about a year or so ago, I think. And so I have that I can, you know.
Have you circulated that to the commission?
I think so, but if not, you know, it's easy enough. It's a document I've got available to you.
Yeah, if you circulate that.
You know, it kind of says, you know, when you're looking at a case, here's, you know, so many days late, have they filed a response? You know, this kind of fine level. Yeah, but I can't remember how long ago it is.
I don't
I remember getting it.
Yeah. So I may not have sent it to you too, but you know, it's out there. You know, so it kind of goes through all those parameters. You know, kind of what fine amounts.
Do you think though, Phil, yeah, if you could circulate that, that'd be great. Do you think so 1 year or less is a reasonable mentoring timeline?
Well, and for point of clarity, we're talking about mentoring of a potential chief of staff, not necessarily the predecessor for the exact role, correct? Or the potential for that to parlay into the same scenario we have with Phil being both positions.
And I had that was part of the conversation that I had with the both groups that I've talked to, as I'm thinking back now, you know, is that, you know, you guys have talked about separating the roles, moving forward on both ends, and there has been a final determination on that. I guess I would say that they are understanding of that, but they, you know,
Towards a one size fits.
yeah, I think that's probably where their head is probably, because it's what, you know,
You're thinking about-
it's what they're used to, let's put it that way.
Delineating between the legal work and the administrative work, is that the point?
Well, there's previous conversation on if it is appropriate for the commission, the executive director of the commission to be both or all, or if there should be separate legal counsel for both commission and the executive director. Obviously, we are blessed that Phil can be one and the same. But if that's appropriate, you know, if Phil's out of town or, you know, whatever the case, it just arose that it might make more sense. There are very few agencies in the state of Ohio that don't have separate or their own legal. So it's just a question of whether it makes sense or not. And
That'd be ideal.
Yeah.
Look at the funding and I.
That's gonna be, that's obviously gonna be a critical issue.
Builds off the same, in the revised, don't we have the authority on some kind of investigator? Maybe somewhere.
Yeah, oh, yeah, it's there.
with all.
But it's, I mean, you can't wait.
We've done that.
Actually, let's say if the money was, for example, we could hire an investigator. Obviously, it's not something.
We're just window shopping.
Right.
Yeah.
You know, or we could engage the auditor's office for performance audit, which is going to probably run, I don't know what they're charging these days, 45 grand.
Different from our biennial audit.
They have a performance audit team. I know, I ran them.
Just double check.
And, you know, you basically, you know, can have it of a specific section, or you can have it of the whole agency, or agency small enough to have the whole thing. And, you know, a lot of it is unfortunately just benchmarking study, but they do get into personnel. They could certainly, I would imagine, they would talk to other state elections commissions, and I bet we would find that position is separated in most cases. So, not that you can tell them what recommendations to make, but I would be hard pressed to see, and I'm on, right, how a competent person could come in and not recommend a split vote, right? Because it's one thing to have you here for 30 years. It's a whole other thing to say, oh, we're going to go and get somebody with the legal skill set and the executive skill set and fit that person under her current budget constraints, right? It's just,
That's not happening.
that's not happening,
That's
right?
not-
So, you know,
Does that?
it's kind of the equivalent of when a large corporation, you know, wants to get an answer for their board and they go and hire McKinsey. It's not, McKinsey just comes in and provides a, you know, 150-page slide PowerPoint that gives them the answer that they want, but it's the CYA for the board to go in and implement a meeting. This is the kind of thing where if an outside group came in and did that, right, and made the recommendation, it helps to create the case. Other than us just saying we need more budget, because their answer is gonna always be no.
That was my question. How persuasive is that? Because we don't want somebody to come in. We don't want to pay somebody a significant amount of money to confirm what we already know. If it would help advance the case.
Well,
Well, we could also for 45 grand hire a junior part-time legal counsel and just call around the.
but that's an ongoing cost. Well, I mean, yes, yeah, but it wouldn't carry the weight. Performance audit group is it's a known group within the auditor's office. They issue reports all the time of government agencies, school districts, municipalities. So they will issue a formal report that is posted.
Get a discount, given the size of our entity is. not even
Yeah, I mean,
a small
you know,
school district.
Then they do it based off an hourly rate, right? So, you know,
Our biennial audit costs anywhere between 12 and 15,000.
I'm guessing it's gonna be the same. I only threw out 45. I was thinking what it cost a decade ago, and I read inflation.
Yeah.
I guess that it's the same range.
Okay, that's what our biennial costs us, because they come to you ahead of time and say, okay, we're about time for you to get your audit, here we come, and here's what's gonna cost, please agree to do that.
Just thinking about it, it might be 50 to even 100% more than that for the sheer reason the biennial audit, they're coming in and they're just doing the same procedures that they've always done, or really updating things.
Correct.
Where this would be a brand fresh look at so you're probably looking at 1.5 to double that. But even if it's double, you're at 25 to 30.
And yeah, and that's not something that I think we would be able to handle at this point unless we don't have. And I know I'm already gonna have to go to control board. I mean, I'm complaining about it, but I know I'm gonna have to do it because as I'll talk about later on, as we start talking about various things, we already have 2 cases in which the AG's office has obligated us to get outside counsel. And so I'm gonna pay for outside counsel. If it wasn't in the budget, so.
It doesn't hurt to go and kick the tires, see what the cards would be.
Quite frankly, I think we just need to communicate with the legislature that these
No,
massive
These are.
inefficiencies are transpired. There's no reason between departments, we shouldn't be sharing legal counsel or CRMs, et cetera. So there should be massive opportunities with all the money that the state doles out to get a few of these shared among small agencies. So I think it's just, we need to go communicate to the people with the pen, ask them to get it right, save the taxpayers money, and they'll move forward. a little
Yeah,
bit.
they're gonna look us back in the face and say, this isn't saving taxpayers money. You're asking for more budget, right?
No, not if there are existing legal staff that are covering other small entities that might be shared.
Oh, you're talking about shared
Yeah,
services.
shared and CRMs, et cetera. I mean, if they've already got state contracts, to
Well, that kind of stuff is low hanging fruit. I'm more referring to, I mean, I think the role needs split. I think if you don't split the role, you're going to have an unbelievable amount of bumps in the road getting the train on the tracks. And it's gonna end up being a lot more costly. Because the person that we're looking for or the budget that we have doesn't exist.
See it, it's leaving.
Right, here's something, how about we work smarter and not harder? So your idea is a good idea. Why don't we ask the Legislative Service Commission for an analysis of that, work with existing state of Ohio agencies? And then just go make the case that we too are an agency.
Sure.
And hey, 95% have their own separate, unique, distinct legal counsel. It's with the matters that we deal with, it would be appropriate. Maybe that
Sure.
is a way just of asking one legislator, hey, can you tap into LSC? Get a couple of answers for us. Do you think anybody,
No, I agree.
just so we don't have to spend what we don't have in the bank? But I agree. I mean, if we need an audit, that's good.
Just, I'm not wanting to spend it. I'm just,
It's an option.
it's an option and if, not that I'm the most political person, but if a state funded group comes in and puts out on paper, right, a official state report that says this is what you should do, it just carries more political weight because right, you've got the auditor's office said that you need it. And they're obviously a lot cheaper than any other group you're gonna bring in. But I'm not spending money for those. I'm just trying to get hopefully get the place on the right footing.
Okay, so let's,
Bill, could you do what the vice chair recommended about the legislative service committee?
You reach out to them.
he won't have direct access, but any legislator would be able to just put in a request with LSC. So if we just say, these are questions we would like answered, would some representative or some senator be willing to ask that of LSC? So maybe what agencies have independent or have legal counsel, not necessarily independent, but in-house legal counsel for that agency in the state of Ohio. And then also they can do the research on who has it across the United States. What other questions would we want to have answered, be able to make an educated recommendation to the governor's office, and OBN, et cetera?
A reasonable budget too,
Oh, yeah, what budget do other, okay, so what budget?
Do we know the of other elections commissions in any other states in terms of how many commissioners they have, things of that nature?
As I sit here, no, I don't have that. I mean, I used to go to I used to go to an organization in their annual meeting. You know, and so I think what you would find is across 50 states, there's probably 40 different setups and organizations. When it comes to and at the time when I was going, I don't think I ever had a conversation with any particular other organization that talked about what the size of the organization was. To be honest with you.
So we don't think 7 is a magic number for commissioners in general.
I would probably, knowing how a lot of commissions go, I wouldn't be surprised that 7 isn't a magic number. You know, but what you get is, you know, some are gonna be 5, some might be 7, some might be 9. You know, you'll have those that are combination ethics and election commissions, you know, together. There's just a broad range of, my recollection is there's a broad range of other times I talk to folks. There's a broad range of organizational forms out there. And I've never looked into what, you know, how big others are, you know, what they do. You know, and then you get into places like New York where they're gonna have I know they have a state elections commission, but the bigger elections group there is the one in New York City. Just because it's so way, there's so much there that they have their own, which is not something you're going to see here in Ohio. So, sorry, I don't have any kind of information. I could try and look at and see what other types of information there is, but I don't think I got much fingertips right now.
Okay, so here are the 3 questions that I have that I believe we can answer. One, what agencies have legal counsel in the state of Ohio and A, in the state of Ohio and B, for elections commissions across 50 states? 2, what budget or other similar agencies in Ohio, A in Ohio and B across 50 states? And then 3, are there shared services opportunities in Ohio with DAS or other places or agencies for civilians or legal counsel to be shared across agencies for reduced financial burden? Is there anything else, or did you guys state that another way?
No, that could be huge, though. If we could have shared legal counsel and then bring somebody in from an administrative perspective, I think that could make our lives a lot easier on this transition issue.
Okay, and maybe even, is there any czar of succession planning? Like, is there anybody that exists in state government for that? Maybe there should be, honestly, for other agencies' purposes.
They're probably good. Or somebody that could assist us with the succession.
Sound good too,
Yeah.
confident in government.
I'll just say I'm skeptical.
I'm very skeptical.
I'm skeptical.
This might be the first conversation that's ever.
I'm very skeptical of there being something like that in the state of Ohio.
Mr. Richter,
And part of that goes back to, as I'm thinking back to my conversation with the governor's commission person. You know, and I'm not trying to take anything away from her. You know, I think she does a very good job. But based on our conversation, I certainly didn't get the impression where she came back and said, oh, yeah, well, you know, we'll have this person reach out to you. Because I think they're, you know, that office, which is where you might think something like that might be beneficial because they're responsible for agencies and commissions. Sure. I think it's probably only about a staff of 4 or 5 people. She's got one primary assistant who is not even that large.
Government has not historically been about moving things along to the next.
I won't totally challenge you, but I know, you know, there's Haley, there's her one primary assistant. I know they've got a secretary. So if they have 1 or 2 more, then I'm.
All right, that's fair. That's fair.
But one could run for governor on the concept of.
This one, that's secretary, that's sufficient.
so Mr. Richter, when you are talking about meeting with the legislature, will someone from the commission meet with you as well? You mentioned.
I haven't to this point. I'm not saying it couldn't happen, but you know, I was anticipating just kind of reaching out. And I was gonna do that in, you know, early next week and reach out. What I was gonna do is go into the, you know, General Assembly's website, get the emails for speaker, minority leader, et cetera, and email them anticipating getting responses back from their staff. And, you know, saying, here's what I would like to do, checking with you, checking, you know, and so that's how I was going to approach this at least initially. And I was anticipating it just being me, initially, but I'm not saying that I wouldn't have a problem with, you know, any one or all of you going along with me or something.
I think initially it's sufficient for you to do it, but I'm just thinking of how you talk about bringing these, really supporting these efforts, because the budget is the issue. That's the biggest issue around all of this. I mean, even us being able to be digitized, it all comes back to budget. So
Oh, yeah.
really being able to drive that home and meeting with them, but again, at a later time. But I think that could be valuable. I don't know.
Yeah, I agree with Davis too. I think, normally I'd love to just have that responsibility of the executive director, because we're in the transition period. Maybe Phil, if you could just let us know when those meetings are going to occur.
Yeah.
So that we could join, you know, if time permits, because I just want to make sure that the institutional knowledge is able to be passed along. And I think it's a sensitive transition time. And, you know, the committee as it exists now, Mr. Knight, Ms. Davis and myself, and I think that we're fully capable of working with you to move the transition forward. But, Ms. Hagan's point, if there's some knowledge that already exists that can help with this process, that'd make things a lot easier.
And if I may, to that point, if the commission would permit it and the executive director, we actually have an asset sitting in the room. Sheila worked previously for the legislature directly under Speaker Cupp. She may be itching to offer time and, you know,
Taking notes.
just.
Never like being.
There's nothing more painful for a former staffer or leader within the caucus than to listen to leaders not get to the punch quicker. So I just think she may have some immediate guidance on how we might talk to the right people quickly.
I would be pleased to chat with you, Mr. Richter, separate from this.
I was gonna say before, well, the other thing I was gonna suggest too is I reach out initially and have a conversation with some leadership over there. But ask, you kind of get off the hook here, Mr. Knight, a little bit, but ask, you know, Ms. Davis, Mr. Wild, Mr. Morris,
The respective.
to be prepared to potentially have me say, hey, why don't you reach out to them, you know, and open up a door there. That might be a more effective way of utilizing you guys as it relates to those kind of contacts.
But my only concern is, though, is you have a JLAC registration.
Right,
We are not permitted to be registered.
understood.
So I want to be very, very careful
Yeah.
that we are crossing the lobbying threshold, because we're not supposed to do it.
Understood, understood.
So I would probably ask for some guidance.
Okay.
On that before I would recommend. So
Could you maybe inform me a little bit more about that? What is your, I mean, directionally understood what you said, but I'm hearing a little bit of Greek. So
no.
like, why would this commission member?
I know someone in the room that does know way more than I do about it.
5%. Generally is 5%, but I'm sure Mr. Bledsoe would be happy to. assist.
Yeah, I was gonna say, I can reach out to him.
But why would one of us as mission members be seen as lobbying?
So why would he, as a staff member, require to be registered, but he is?
I'm registered lobbyist.
He has a JLAC registration.
That's, what's JLAC? I don't know.
Legislative Ethics Committee that's responsible for, let's say you wanted to be a lobbyist.
I do not, but go on.
You're making it do. You wanted to be a lobbyist and you had whatever issue it was, you know, water issues in Delaware County or something like that. You wanted to address the General Assembly. You have to file with the Joint Legislative Ethics Commission, you know, just a generalized statement that says, hey, I want to lobby and I'm going to lobby on these issues.
Because you're asking for additional funding for the Elections Commission is your point?
Yeah, it's a mild concern. I just would like a legal, just so we can use those conversations.
Yeah.
What if a private citizen just can go and address the assembly with their thoughts?
Mhm.
Like, so.
Yeah, but if you're planning on doing it on a more organized basis, and on a more regular basis,
Okay,
you know, then you you kind of, you go beyond that.
Okay.
You go
Was
beyond.
Mr. Vice Minister, because he went to a number of meetings with you on things, right? Mr. Kreitz, when he was a commissioner.
Yeah, we went and talked to, but we weren't talking about,
Structure rather than-
yeah, we weren't talking about finances or anything else like that. What we were talking about was possibly making some changes to the elections commission's format, let's say.
And as they're being inflicted upon us.
And, you know, right, and he, what, we probably met with him for about an hour and a half.
So it's like, we're lobbying.
I'm not trying to prove.
Represent.
I just want to make sure that
It's a good point. It's a good point. I'm sure this is a public meeting. We do have a guest. I don't know if there's anything that would be helpful, but I welcome any
If you
insight
want
that
to
you may
take up the
have.
hat in which you put in and just be a normal Ohioan advocate for better government, we welcome you to that.
Respectfully, I do, as you know, have 2 children in daycare, so I apologize. I am actually a registered lobbyist as well, conveniently. But I obviously won't give you legal advice, but I would definitely recommend Mr. Richter speak with Mr. Bledsoe. Obviously, if you're compensated, there's a certain percentage threshold that if you're advocating for something, then it could come into play. So best practices, but I think there would be a path forward. Just talk with Mr. Bledsoe about best practices. He's wonderful.
Oh,
Hopefully that sufficiently answers. Madam Vice Chair, thank you.
Mr. Bledsoe, shit, had conversations for years. We used to work in the Secretary of State's office.
it's just good to be on the side of the question.
Yeah.
You do it.
So I do have one question. I hate to go all the way back. But we talked about this person shadowing you, where I'm a little confused. Is this someone that we would approve and hire? And then they're going to be in this mentoring phase for a year? We talked about them potentially not working out, then we would interview and hire someone else. Because we're talking about someone coming into shadow that may not work out. We're talking about them actually getting the position, correct?
I don't see how we would be able
Yeah,
to bring
okay,
somebody
yeah.
in, just, you know, on the come.
Right.
Maybe. Join us in maybe.
Yeah,
Negative position.
yeah, maybe that'll be fun for
Is
you.
there such a thing as probationary hiring in government or is that?
Oh, there is, I'm sure it's a structure of,
Yeah,
90 days.
I would do a
90
90-day at minimal for this
Yep.
significant.
9 days. At least that's always been the standard of which I've been aware. I passed that back in 19.
Congratulations, if you served many 90 days. That's-
Yeah,
a little bit beyond Ohio's ante.
I wonder, would you say that you had communicated with the governor's office of, yeah, no, nothing has shifted in your timeframe, correct? We're not working, okay.
No, although I did say though, that I said to governor's office staff, I said, you know, hey, come up with somebody that you think is a good candidate, and you guys all approve it. And the timeline speeds up. And, you know, I don't have any problem with that.
We prefer just the opposite.
I understand, you know, but I'm saying, you know, if it works out that there is somebody that, you know, comes to our attention and if it all works out. And I'm, you know, and I'm done in a lesser time frame than 2 years. I don't have a problem with that. You guys all may. I'm not trying to scare anybody, you know, because I'm certainly not saying I'm just ditching. But, you know, that was something I discussed with them, at least in generalized terms. So, you know, just to get that out there, I've said that to say, hey, you know, if you got a great candidate, the person comes through and everybody's okay with it and it works out. I can, you know, I've gone past 30 years.
So Phil, just so we're clear here, because I don't think, you know, we want to keep you around the middle. Like I said, when you guys get a concrete couple, 3 next steps, I think the LSC piece is important, but so we can kind of move beyond the issue.
Yeah.
What do you think? Yeah, what,
I'll see. Like,
and then continuing conversation with the governor's office.
Yeah, and reaching out to the folks in the General Assembly, the leadership of the General Assembly. You know, and then, you know, bringing back to you guys at least a tentative budget, because as I've explained to everybody, and I tried to curry a little bit of favor with folks over at VM, because they changed the way, I explained to some of you, at least they changed the way they do budgeting the last time around, so that now you actually do put in a budget They didn't necessarily approve everything that I put in the next time. Because prior to that, they told you what your number was. And just kind of said, you know, here's what you get. You can ask for a little more if you want to, but here's what you get. And so, you know, I could put in a much more robust budget this year. There's no guarantee you get it, but at least you now have that ability. So when as we discuss this and we start going forward, I can say, okay, we put in this for this, and this, and this, and this, and this, and this, put it in, and then they're going to look at it and say, okay, yeah, you don't get that, you don't get that, yes, you do get this, and, here's why. So that's a nice, to me, that's a great situation to have. Because, for the first time, well, I did it 2 years ago, but even then I kind of went from what we had and just added a little bit. Honestly, this time around, I'm actually going to be thinking about, okay, here are some things that I'm going to add to the budget to put in. And then, it goes, certainly part of it would be bringing someone on, hiring someone, and putting some money in for that, but it's also other things that in the past, I really couldn't do. So talk about that later on.
I'm really interested in the LSC piece though, because we might be able to operate within the confines of the current budget if we're able to have shared services.
Thank you.
And so I really think that element could develop.
When you, I hadn't been, I'll be honest with you, I hadn't been totally focused on, when you talk about shared services for council, what exactly are you talking about?
Well, what I mean by that, I think maybe what Christine means is that, are there other governmental agencies that have legal counsel that could assist with the with the legal aspects of this position, so that the executive director would be more of an administrative position and the legal issues could be addressed? And certainly there are other agencies with a significant staff of attorneys, including those with expertise in elections law.
It's potentially, the difference is, in my position, this position is one of only a handful that is given the authority to act as legal counsel to the commission, aside from the Attorney General's office. This position was great. This position, obviously I'm in it, but it's not because of me. This position was granted the authority because on the commission, one of the issues that was, let's just say, a focus at the time was the fact that the old commission was administratively handled by the Secretary of State's office, and legal advice came from the Attorney General's office. And those two officers at the time, it was Lee Fisher and Bob Taft, both agreed that they had concerns about the fact that there was potential, a view of potential conflict of interest, particularly in the AG's office, for acting as the attorney for the Elections Commission when matters could come up with the Elections Commission that involved the Attorney General or the Secretary of State. And so when the commission was created with an independent agency, there is identified a staff attorney to the Elections Commission that has the authority of the Attorney General's office to advise the commission, that, obviously when we get sued, and I'll talk about that at some point here, I still go to the AG's office and they represent us outside of this office. But in the confines of these meetings, and as it relates to your activities as a commission member, I am your legal counsel, not the Attorney General's office, and that was not the case previously. And so this particular, and I've never been able to specifically identify how many. My understanding is there's only about 3 or 4 people across the state of Ohio that have the distinction of being the legal counsel for the organization for which they are serving.
Is that codified or are you just grandfathered?
No, that's codified.
Okay.
that's specific in the statutes.
Okay.
Yeah, I just want to explore all opportunities, especially given the.
I don't disagree with that, but I'm just saying this position is different in that I am your legal counsel and it's not the AG's office.
Well, I think that helps to validate the point of why we need a higher budget then, right? It's codified that we should have this individual legal counsel. So to me, it helps the argument.
Don't necessarily disagree, but I don't- who knows what the program's gonna be. That's that.
Unless it's uncodified. We make the argument too strong, but no, you're right.
Yeah.
You mentioned earlier, and this is, might be way off track, and I don't mean to be this down right, but when you were talking about the records and all the records pre-existing, are those physical records or electronic records? And do we need to put in a budget line item requesting for some way to transpose those to electronic format if they're not already electronic format?
Some of them are on this computer
Okay.
and
The rest
the
are.
majority of them are on a shared directory
Okay.
that we have. It'd be easy enough for me to transfer from this.
Okay.
Share
So they are
directory.
electronic.
You do that every so often, so, right, every couple of weeks, you transfer over in case.
Honestly, I haven't transferred. You're right, I should. I haven't transferred.
This thing, this Dell.
Yeah.
This thing goes down. Seems like, oh, the V and the P mix up is not my biggest concern today. So,
Well, Madam Chair, I think we had some good discussion on this. I'm ready to move on if the group is. I'm awfully interested in these lawsuits. For one.
Yeah, well, there's not, first off, you've heard me refer over the years since you've been on the commission, the Freeman case
Mhm.
that the commission made a decision on. Our decision was approved at the police court level. It was approved at the appeals court level. Mr. Bride, then, who represented Mr. Freeman, dropped out. My understanding was Mr. Hartman picked up the case for Mr. Freeman and requested and submitted a request to the Ohio Supreme Court to hear the matter. And Tuesday, we got a response from the Supreme Court that they were not accepting his request to have the matter addressed by the Supreme Court. So our decision has been upheld. The primary essence of that decision, as I've said repeatedly, I expressed to folks whenever we had the opportunity, is one of the things that the commission decided as a part of that case was it was always, and it was always my general understanding that if you did not have a bill, you didn't have to worry about paying a bill. You didn't have to worry about including on your campaign finance report, you would not bill, et cetera. The biggest part of the commission's decision there was, even if you don't have a bill, if you have strong knowledge that the facts will establish that there was some kind of an amount out there that you needed to reflect, you at least need to do something with your campaign finance report. That was kind of confirmed when we did the Gene Schmidt case as well. I'd say the primary factors in the Freeman case were the fact that he participated in the production of all the television commercials that were involved. He improved some of the language, he was actively involved in television commercials. And so, and the fact that he knew they aired and they ran. And so therefore, the commission said, no, you can't just not accept that there's something out there as well. Include that in your campaign finance report. That's the biggest thing there. So that was done over with.
Bill, may I ask, is that a guesstimation based off of a previous quote you received? If there was no quote, is it just, this is generally what this runs? I'm just gonna plug a number for the candidate's responsibility.
We really didn't put any, I'd say, real definitive, well, there was not a definitive amount involved. It's just a matter of, okay, if you participate in doing all this stuff, you need to reflect something out there, depending on the nature of what.
Advisory opinion help.
That I could probably take what we did in that decision, turn it into an advisory opinion, if you guys want me to do that.
I don't know what the other, because,
To get a little, because right now all we have is the decision.
yeah. The argument of, I never got a bill, so I'm not gonna reflect anything, just doesn't really pass the smell test. When you know something is ran, but to the vice chair's point, what is that amount? And so if you have an amount and you just kind of guess, then have you at some point provided false information? Have you knowingly provided false information on your campaign finance report? I think it's a really gray area. That maybe an advisory opinion to help future,
Right,
um,
and maybe it's just a statement of
yeah,
what was purchased or what without that financial commitment, because if you're guessing, you're either high, low, somewhere in the middle, and then that's what's documented as a code.
Right.
I think that's what.
Oh, okay, yeah, it's something I can consider, trying to put something on paper. I think it wouldn't have been appropriate to do it any earlier because it was always possible going through the process that our decision could have been overturned. And they could have said, no, he didn't, the commission had no basis for making the decision. They hadn't done that, now we've got support all the way through the court system, so.
And the court has said it sounds like if our decision is supported by reliable, appropriate, and substantial evidence, that they're going to defer to our expertise, which is what you attempted to do in the end.
Yeah, so, okay, I can start working on that. There's 3 cases that are currently outstanding. Well, there's more than 3 cases. One of them I'm not gonna get into, that drive me nuts. But first off, we were supposed to have on the agenda today, another complaint filed by Mr. Hartman against Weinstein, if you all remember that particular case of, whether they were, what type of the organization they were, whether they had filed a report that Don McTighe argued. Well, Don is representing Mr. Weinstein again. This time the allegation, this time the allegation is that when the contribution was made to the clock tower, that was all part of that, Mr. Weinstein signed the check, not his treasurer. And so the allegation is that the treasurer, that an expenditure was made by the campaign committee that was not in the control of the treasurer. That's the issue that we're going to have, and it's coming up on August.
he assigned as a deputy treasurer.
No, supposedly not. So that's coming up. Anyway, my reason for that is, if you recall, when we dismissed that case, well, Mr. Hartman has appealed to the Claremont County Court of Common Pleas, our decision, and currently pending in Claremont County Court of Common Pleas. Generally speaking, when complainants have appealed our cases or taken them to the court, let's put it that way, we have been able to get those matters dismissed because the general understanding is when the commission makes a finding against someone, against a respondent, there is a taking from that respondent. We have taken, even if it's just reputational, we find a violation of good cause, and, that is enough to give that person the standing to file an appeal of the commission's decision. But a complainant does not have that same taking from that person. They brought a case to us no different than, say, somebody bringing something to a grand jury. And if the grand jury says no, it's kind of done and over with. Well, we looked at it and we said, no, it's done and over with. Regardless of the case, Mr. Hartman has filed an appeal. He has taken that before the court. I filed the transcript. The AG's office is representing us there. I had a conversation with them the other day. They're going to submit a motion to dismiss in August. We're hopeful that the judge will take it based on that general finding. But I've also kind of been given the understanding that, and generally knowing Mr. Hartman, doesn't like that kind of finding, and so I wouldn't be surprised if that one stays in the court system for a while. Let's put it that way, because even if he gets a negative decision, I'm anticipating it to go on for a while. So that is not costing us anything.
But the only thing he can do at that point is appeal it to the Supreme Court, correct?
No,
It's at the common
it's
pleas
common
court.
pleas.
So he can go to the appellate court.
He go to the appellate and then presumably the Supreme Court. And all that would do is hand the case back to us, and we'd have to.
Yeah.
What's that?
There's two cases, or there's stuff.
There are two cases that the committee, they have been filed against the commission in which outside counsel has been, the AG's office is obligated outside counsel, so we're gonna have to fess up and pay those at some point. The first one is, you're all aware, well, you guys might not be as aware, you're all aware of One Worthington, okay? Mr. Bry has filed an injunction suit essentially against us to try and essentially keep the commission from going forward on a hearing in that case. And for some reason, the AG's office couldn't represent us, and so they put it to outside counsel. And so I've been working with outside counsel on that. Essentially,
What's the reason they couldn't?
because the commission, part of it is because the commission didn't go along with my recommendation to dismiss it, and because the commission issued the advisory opinion in the Citizens United, kept me out of the Citizens United case in 2010 that says we will more or less decide those kind of cases as the Supreme Court, the U.S. Supreme Court directed, it's Citizens United, and so therefore the commission should not have the ability to go forward on this case. I know briefly I discussed this matter with Mr. Lyle because his suggestion was, isn't that a little preliminary? And it's like, well, yeah, I mean, my opinion would be yes. But Mr. Bry has filed his complaint, and so it's got to be dealt with. I said to him, not just to pick on Mr. Lyle, Mr. Knight, but you have expressed during the preliminary review when we reviewed that, not that there is a violation, but you believe that there is enough to have us go forward and review the case. There's at least probable cause. There's no definitive decision, but he filed that complaint so that, we presumably don't have the ability to have the hearing on it.
That's right, because there was it was like one of my first meetings that some of the council, someone's claimed they didn't get served or didn't get notice.
Right.
And we had to
Right.
review it.
Right.
Yeah, okay.
Yes.
So I still,
He was right in that particular situation, so that's why.
Right, yeah, and so we
didn't change the decision.
So anyway, before you have your statement though, that is one case that you're being represented by Texas.
I still don't understand why the AG can't represent us.
I
mean, all that you said is true, but the connection to the AG saying they can't is.
I don't know the answer.
Okay.
I asked the same question because too, when we first got that and I sent it over to them and I hadn't heard anything for a few days. And I reached back out to the person who normally represents us in the AG's office. I said, no, there's a conflict and we have to seek outside counsel. At that point, they were having a hard time finding somebody who wasn't otherwise.
But what is the conflict?
Well, they don't necessarily, they've identified a conflict, they may not necessarily have to disclose.
Right.
Well, let's hypothesize. What could the conflict
Well,
possibly
it
be?
doesn't matter in the sense that the
I don't
AG is
know the
not
answer.
going to handle the case.
Right.
I mean, but I guess as a taxpayer, it matters to me because we're gonna have to now go out and spend, private sector dollars, an unknown amount, right?
Right.
And I know that these folks see that and they just charge by the hour and they run up the bill. So, it matters to me.
Right.
What is the conflict?
It matters to
What
me
could
as
it
well,
be?
and I couldn't get an answer. I couldn't get an answer.
Because I mean, they say there's a conflict and you don't have to disclose it is fine, but I mean, I'd like to at least understand. Do we have any idea what it could be?
No.
Okay, fair enough.
I'm sorry.
Fair enough, I'm just
I
saying.
have asked the questions and I have not gotten any kind of definitive answer. So I have no idea if that's going to take a year to go through, if it's going to go through quickly. Not today, but maybe I'll be reaching out to council to see if we can potentially go forward on that case, because I had it all set for hearing. We were within days of hearing when he filed this. I then had to continue the hearing. Mr. McTighe was not real pleased with that. I subsequently talked to him about the reason why I did it out there because he wanted to continue to push the matter forward. And I indicated to him that I would reach out to our council, see if there's any kind of submission. I said that the interesting thing, well, I don't know if it's interesting or not, it's interesting to me, is that just recently, Mr. Bry filed with us, and we have then responded to that with a pleading about who might have information on this particular issue. Certainly, I was listed, considering my position, the fact that I wrote the advisory opinion, but he also listed John Markowski, who was the chairman of the commission at the time, because he signed the advisory opinion. The commission members on the were on the commission in 2010 to approve the opinion, and all of you, because you have this case pending before you. And I wrote a response to our council, that kind of laid out what I thought of some of those bases. And I subsequently reached out to Mr. Markowski, because I said, with all due respect, my recollection is I wrote the opinion. I did it pro se, because there was no question before us, but it's after having seen the Citizens United decision, I decided to write the opinion to essentially to forestall any other potential challenges to Ohio's statutory scheme, because I can see an attorney filing a complaint doing a 1983 action, having to walk over and get some money. So that's why I did it primarily. And the commission approved it. And I said, Mr. Rokowski, I don't know if you'd have any more information on that.
We just even remember,
He does remember it, because I talked to him as I was driving back from Cleveland, and he said, "You're right, Phil, I have no other information on that."
85 or
Yeah, he's 85 years old now, but he said he's doing good. So it was good to talk to him, get back on him. So I don't know where that's going, or what's going on, but that's one that's out there.
Well, wait, us being listed as people who had information, does that mean we would be, they're gonna interview, subpoena,
Well,
depose?
our response back just listed myself and Mr. Markowski. They did not agree that all the commission members or you guys had anything about, anything of value to add in terms of that suit. Please don't take that.
To set my value away.
Thank you. I don't know. Yeah, it's certainly possible. I guess he could. The question was asked is, what have I done to you guys? I gave them the advisory opinion. I gave advice on what I felt, should be the finding of the commission. I've talked about it during commission meetings, et cetera. But that's the only, you all only have the information that I've provided historically and as it relates to this particular case. So I don't know where that one's gonna go. I'll try and get some more information on it. But that's where we are with that one.
When you say you're talking to council, who are you referring to?
Like the gentleman at Texas and Hollister, who was the council's son.
Okay, that's who, okay.
I could give you his name.
Oh, no, that's fine.
Because I got it in the emails.
But that's who we use.
Yeah, that's who they assigned it to somebody, and they find it.
Yeah, you assign it to them. And then we have to pay for that individually out of our budget, at what, $500 an hour at least?
It's a
Maybe state rate.
Yeah, but it's what they send is, you're going to outside counsel, and at this point, at least it can go up to $20,000 is what the potential expectation is. And when we did
There's
that,
a cap on the finances.
right, well, we've done that on other matters.
Okay, that's good. Thank you.
That's the essential agreement you come to when Borges filed a suit against us to try and prevent us from going forward. And we had counsel there. That's the letter we got. It ended up costing us like $12,000, $13,000.
15 hours not to exceed 20.
Exactly.
Okay.
But if it goes on long enough, it should take a issue. The last one I want to talk about is the Ohio Chamber of Commerce. Speaking of the Citizens United decision, because this is kind of an offshoot that the Ohio Chamber of Commerce filed suit against us, which are Secretary of State's office and somehow the AG as well. We had a conversation about that. Challenging 359903's prescription on corporate activity with individual candidates that has been in some manner or form in place in the country since 1907. My history on that one way back when, and Ohio's version of that. Well, I should have brought my stuff along when I did my presentation the other day. Ohio's version of that dates back to about 1910, 1920, somewhere around there, that prescribes corporations from essentially using their corporate influence in the political arena. The Tillman Act was what was originally enacted on the federal level that puts that prohibition out there on corporations being involved in individual candidate campaigns. The Ohio Chamber is challenging that statute as being unconstitutional. And we and the Secretary of State's office are being represented again by outside counsel. The AG is representing himself, or, internally, they have got somebody in the AG's office representing there. We have no idea. I have no idea where that one's going to go. I certainly feel like the statute's been there for a long time, and it's, been previously upheld. One level you could say Citizens United didn't declare it unconstitutional when it did make the decision that it did, that it could act independently. And the statute's been there for a long time. Let's just say I've gotten the impression that Secretary of State's office may take a different view on that. But we'll see what ends up getting filed. But that's the other one that's out there. Similar situation to the Scott case, where we had outside works, right? Now we reinforce. They could change it. Yeah, exactly. Well, and that's one of those things where I wrote the Citizens United advisory opinion when I did, because it had only been a short time, and there was talk about.
You actually have to remember how much.
Is your advisor?
They're challenging your advisory.
No, they're challenging the statute.
Okay.
They're challenging the statute.
Okay.
But my advisory opinion will be fine. The commission's advisory opinion will be a part of, I'm sure, the argument or against. I didn't really address, I don't think I addressed maybe I did, the conclusion on corporations, acting directly in concert with a candidate, but that's what they want to do. Because essentially, I don't know, there was an article in the paper when it was originally filed, about a month ago, that said that the U.S. Chamber feels that they are at a disadvantage, restricted by this statute, to labor unions who have the ability to use their corporate funds on behalf of individual candidates, and corporations cannot do that because of this preclusion. So that's the Chamber's essential argument. See where it goes. I've taken a position. You guys want to take a different position. Please, you guys can go. We can discuss it here, whatever. But essentially, my position, as I think is appropriate for this position, as you said, we're responsible for enforcing Ohio's statutory scheme. It's a statute been in place for over 100 years. It has been in place for a long time. The intent is to keep corporate entities from having undue influence in the political arena. That's what's been long stated. That's why it's there. I think as an administrative body that's responsible for enforcing Ohio statutes, I'm taking the position that that's where we should be. Sorry, go ahead.
Are the labor unions not operating as tax? I'm thinking about how that check is coming from.
Well, see, back in the mid 90s to late 90s, the General Assembly attempted to include labor unions with corporations under 359903. And there were two separate cases.
Very hard.
Well, they wrote it, they put it into the statutes and it was, the labor unions challenged it, and they won. And as I sit here, I couldn't give you recitation of what the essential holding was, but they said, no, that's, it was an unconstitutional burden on labor unions, it was okay. So then a couple of years later, in an infinite wisdom, the General Assembly tried to do it again, essentially saying the same thing. I was part of some of those conversations where we'll get a different judge. This is one of my favorite old stories to tell. We'll get a different judge. And so it was challenged. Commission was included at that point as well. And they did get a different judge. They got John Bender, who was the former legal counsel to the Secretary of State at the time, who was my boss when I was at State's office. And so they got John Bender. And all the parties together into a room around conference tables like this. We're all sitting there. Judge Bender walks in and he looks at everybody and said, all right, help me understand how this case and this statute is any different from what was decided in PISA, which was the decision that overturned the, declared unconstitutional what was done previously. And after about a 2 or 3 minute pause with nobody saying anything, representative for the Attorney General's office went into the spiel about how it's this and this and this and this and this. And Judge Bender, then my recollection is, went back and said, I don't know that I'm buying that. At which point, eventually down the road, he made a decision that was the same as the PISA decision before it. That again overturned it. That was upheld on appeal, and since then, labor unions have not been included in 35993. Only corporations have been included in 35993 until this was filed, and so we'll see what the court decides here.
I'm not sure most recent advisory opinion issued, what date
On
or year
what? On
this matter
on
was
this.
being considered for this case?
2010.
2010.
Citizens United was 2010.
You mind forwarding us that opinion? Because you're asking for feedback.
Sure. Sure, I would.
Because that's the standing voice of the commission.
That's,
right?
that's,
So
yeah,
whether
that's the
we-
commission has taken, and it was, Citizens United essentially said, no, corporations still can't make contributions to individual candidates, and this was done on the federal level, because it was a challenge to the federal statute, which is very, very similar to Ohio's. But corporations have an ability to act independently, and as long as they act independently and in concert with a particular candidate or an individual candidate's committee, they have an ability to do whatever they want. And so my advisory opinion on behalf of the commission was essentially to say, we will enforce Ohio's preclusion in a similar vein and manner to the holding in Citizens United, and that we will allow corporations to actively participate in the electoral system as long as they don't involve themselves with a particular candidate. So that's the essential holding. So there's my long-winded explanation of the various legal matters that we have outstanding.
This is why we need more than 1 year for onboarding, because we spend 1 year right now. But in all fairness, thank you very much.
Sure, no
The
problem.
historic education.
I'm sure, credit cards, are we up and running?
No,
Okay, well,
which is not, which I'm not real happy about, because I had a feeling I'd have to. The group that's been supposed to set up our online stuff has never gotten, oh yeah, they got back to us about a month or 2 months ago. Yeah, we'll get right back to you. And then they never got right back to us. And
I made
honestly,
get back with it.
honestly, I have dropped the ball to a certain degree, admittedly. But once we started talking about this, I had that OG moment
Yeah.
that said,
No, I wrote it down earlier, credit card.
Right.
Mark.
no,
What was the quote on the CRM system out of
$40,000.
40,000?
A year or upfront cost.
40,000 up front.
10,000? Or was it? Because it was a
Or the
minimum
number of
of
five.
50 users.
Yeah, wasn't it?
We only need 3 users, so can we?
Well, there's a minimum of 10, so you guys could all access it if you wanted to.
Build our.
It was at 1,000 a month,
I want to say something like that.
1,000 a month for 10
Do
years.
they have a non-profit version?
Not that I'm aware.
I mean,
That's what
joking, but sometimes. there are-
Yeah, no, we got the contact through the person is the Liquor Control Commission. And I also know from at least briefly talking to Paul Nick at the Ethics Commission, you know, they're using this group as well. And they've been very pleased with how it was implemented, how the transfer of data, et cetera, took place, and where they are. So
Try to think, just for a moment, a little bit outside of the box. Because for example, what we have at the Elections Commission and what the Ethics Commission has, I'm sure universally are public records. There are not a lot of shielded records.
yeah, it's one of those great, it depends, you know, when you file your ethics report, you know, that is a public record.
But the address, it's gotta be blocked down, maybe phone number or whatever, right? So my question is it a possibility for us to piggyback off of a subset of the Ethics Commission account? That to be able to jointly use, I mean, there isn't anything proprietary.
I think the simple answer that I can give you right now is my understanding.
Because
that's kind of a question we ask, you know, in terms of, hey, can you do this, it's like, no,
So it's in the LLC questions.
each one is its own thing, because when the Liquor Control Commission does it, they're in contact with them, they make arrangements that, you know, and certainly system different. But that client in this group, yeah, I say there's Ethics Commission client, they have. There are others. You remember who else they talked about?
I'm just surprised there isn't just one
Off the
big
top of my
account,
head.
yeah, with different subsets. Like it's,
That would require EAS to do their job and do statewide procurement, and opposed to, what they do now, which is, you know,
everybody do their own thing.
well, they bless certain things, right? And then everybody do your own thing that's blessed.
That's pretty fair.
By your own saying.
Let's say, going way back, Chris and I originally we talked with another group that just kind of dropped us like a bad habit. But we also reached out to DAS and said, you know, here's where we are, you know, working with a Microsoft product. It's, you know, that's our database. Here's what we think we need to do. Yeah, we have none there. We'll get right on that. We'll get back to you.
How long?
5 years ago.
About that,
5 years ago.
we're still waiting on that phone
But
call.
we're still waiting on that phone call back from them in terms of
Well,
what
my concern
what they
is,
should be.
and I'm not, you know, sometimes when someone doesn't call you back, we've got to call them back. You know, like stay on top of it.
Oh,
And,
agreed,
and I'm assuming that's happened, but,
agreed,
yeah, okay.
agreed.
We were gonna talk briefly, Vice Chair, about, some of it came up earlier, with the Clark County, I think they're Kevin F. and Robert Langora.
Oh, no, those are Lucas County.
Oh, yeah, the accruals.
Right.
Right, so obviously I wasn't at the last meeting. I don't know if you guys had a discussion with the commission, had a discussion about that, the threshold.
Not
That's what you
really,
mentioned.
Yeah.
but
Last meeting?
Yeah,
no,
okay.
no.
Okay. She brought it up today, so I had to.
Yeah, no, I know.
Taken.
Saying,
Okay.
The issue that we discussed and that I asked for an update on, either at this meeting or prior, is just what's the status of internal matters Chris was gonna address that have been referred to the AG's office, what those parameters are, and how the AG is doing on those collections.
Okay.
What I didn't realize before last meeting was that when we have significant fines or fines at all, the enforcement entity for us is AG Special Counsel. And so you have that update.
Well, see, first off, I'll just interject, it's the AG's office, if they decide to send it out to special counsel, that's their choice, once we send collection matters over to them.
But we have to send them over to the AG's office.
Correct.
So the first issue is, what is the status of our internal work to refer matters to the AG's office?
Okay, in what regard? My reason for asking, is So with every meeting, just like take this meeting, for instance, that there are, let's say 30 cases that have a fine imposed. When we approve those minutes at the next meeting, for instance, we will send our disposition letters out at that point, saying, hey, you've got a fine that needs, paid. If you've got a per diem fine imposed, make sure you file a report, and then you can ask for reconsideration, et cetera. We send those out, folks will pay the fine or they don't pay the fine. Eventually, what would happen is we would send a second letter out, which we have found to be tremendously helpful. Surprisingly enough, to give an additional, we call it a 15-day notice. It says, hey, we imposed this fine on 7/25. You still have not paid your fine. Please make sure you do so. We're giving you 15 more days before it goes to the Attorney General's office. And it's actually been a very productive letter to send out that we will inevitably, out of those 30 cases, there will be at least 10 of them that will send a check in.
Is that a new concept?
or the
Or is
request
that
reconsideration.
That's been the ongoing thing.
Okay.
And we've done that as with finish.
So it's there.
Now, once it goes to the Attorney General's office, then it's
Well,
out.
I don't want to deal in generalities, I want to deal in specifics.
Okay,
How do you track all of the fines comprehensively, whether they've paid or not paid? How do you track them? Is there a specific spreadsheet that tracks all of them?
so we get a check from the AG's office. When they send a check to us, it's a lump sum that you'll get a check that,
Well, let me ask you this way. If I say, Chris, I want to know everybody that we find over the last 10 years and the status of those payments, including those that have been paid.
Yeah.
And those that have not been paid. And of those that have not been paid, the ones that have been referred to the Attorney General's office for collection. Is there one spreadsheet you can give me that?
so the AG does provide, like, if we were to ask them, we want an update on our list.
But we issue the fines.
Correct,
We send the first letter.
Right.
Correct.
We send the second letter.
correct.
How do you track that?
So
I would say there's not one document, no.
No,
At this point,
it's-
there's one document.
it's
Maybe
either
there should be,
must
there's
be.
not.
There, I mean, do we
there are-
have a good record keeping system to know who has been fined? Who has received the first letter? Who has received the second letter? Who has paid? Who has not paid in one central location? Because if not, that seems to me a problem.
So if you were to look into our,
Just
File.
answer the question,
Right.
do we or do we not have that centralized location?
there is not not a single document that you can pull up the
So
list.
how do we know?
And that's what I'm getting to.
Yeah.
So when we send something to the Attorney General's office, there is a separate file cabinet that goes in from our other fines. When we've got our fines due file cabinets, we've got our Attorney General's office collection file cabinets, and we've got what we refer to as our dead file cabinets. Those are files that eventually will go to storage. Now, as far as the document, when something is referred to the Attorney General's office, we send them in batches, sometimes of 10, 15, 20, 30 different cases. And there is a document or a Word document that's created that gives a spreadsheet of who is being sent over, what the amount is, all of the addresses for.
Do you track that?
Yes, and so that is on there. Now, when a check comes to the commission from the Attorney General's office, it said it's usually a lump sum check that's $4,000. And you print out a spreadsheet from the Attorney General that says this much is coming from this account, this much is coming, from this account, et cetera, and it will show how much they have paid to date, what they have owed or what they still owe on that account. And we will enter that into that Word document. So if you were to say, hey, pull up John Smith for me, I want to see how much he's paid, we can pull up that document and say, well, it looks like we've gotten 3 checks from the Attorney General's office for $15, $97 and this, and be able to tell you what he's paid.
Do you have cases that on which money is owed that have not been sent to the Attorney General's office for recovery?
Say that one more time.
Well, no, I'd say, right now, I'd say yes.
Okay, so
We've had some about, over about the last year or so. I think,
Yeah.
is probably, where we're at least to a degree behind on getting those kind of things over the.
do we know, Phil or Chris, do we have a comprehensive list of everybody that has had a fine issued against them that owes but has not paid?
I would say we do not have a comprehensive list of
So
that.
how do we know?
Short of in the database,
Right.
our database will reflect that if you put in certain parameters, I mean, without going through and looking at 40,000 cases that are in the database, if I were to pick, the last 2 years of meetings out there, I can see the notations in our database to see if there's still fines that have not been.
Does this strike you as effective or ineffective?
It's.
To us to say, that's an interesting question that, and you're certainly welcome. Some of that, he's doing his best to answer. I have not pushed for something like that. So if you want to point a finger, I'm certainly.
Well, not pointing a finger, I'm pointing
I'm really
it out.
saying, yeah.
If you're gonna remember, if we're gonna.
Because I honestly, I hadn't thought about that.
If we're gonna take the time to issue fines.
Yeah.
And we've got concerns about recoveries. I feel as though as a commissioner member, we should be able to say. What if we take the time to consider these cases and issue fines? Then we should take at least the same amount of time to track. Especially what's not being paid. So that we know what the status is. It seems to me as a commissioner member, I should be able to send an email that says, I'd like to have a list. An Excel spreadsheet or some other form of everybody that has not paid and what the status of that matter is. Because it seems to me that some of our work here is for naught if we're not tracking it. That's one. So I think we ought to implement that. Two is then, what has been sent to the AG? Where are we at on? If we don't know what is owed, then how do we track what's been sent to the AG's office? Is it just that we receive what we receive when we receive it and we thank them for it? Or do we have some sort of internal tracking mechanism that we can determine this is what's been paid, this is what's not been paid, here's the percentage of recoveries that we've received, and here's what's up.
That portion we do not have, to be able to say, look at a percentage of what's been recovered.
We just send them out. When they send us money, we say thanks.
Exactly. Once it's sent to them, it's out of our hands as far as it remains active in our office in those active AG file cabinets. And the Word documents will reflect what has been paid, if anything.
But if I said, has 100% been recovered, or 25% been recovered, or 50% recovered, you wouldn't have the ability to specifically respond to that.
That is correct.
I would agree with that.
Unless there's something I'm overlooking.
We had asked you, is there a line in the sand on these like $50 fines? Say you had a $25 a day fine and only went one day and that's that. With it being turned over to the AG, is there a certain line in the sand which it's cost prohibitive to actually give it to them? Like, does it make sense for it just to go to them?
We're obligated to send everything to the
Okay,
agent's
so
office. that we
regardless.
do. Yes, now, don't ask me for all of the specifics of how the AG works. Because I can't say I know for all the specifics, but I know that they certainly will treat those types of things differently.
They're not gonna prioritize what they can't collect on.
Correct.
So we're.
You can't hold them accountable for things that we're not monitoring
Right.
or documenting.
Right.
So then also this right file, the dead file, what is the definition of a dead file? Does that mean it's been paid, or does that mean we've given up on payment, or a certain amount of time has been passed and we just are writing it off?
Our dead files are ones that either no fine was imposed or the fine has been paid in full and the case is closed. Record retention wise, we keep those files in office in those dead files for 5 years, and then they get boxed, taken to storage where they're kept essentially indefinitely.
Okay.
But that's all that is in the dead file.
I don't know how to address the resolution, but, when we shifted from electronic file, from paper files to electronic files, the advice that we received, I think wisely, was, look, you can't go back and recreate history, but you pick a certain date from that date forward, everything gets scanned, everything goes electronic. I don't know, and I feel I challenge you, what to do about the historical information and data as it relates to fines and recoveries.
Mhm.
But I think starting today,
Okay.
if not sooner, we need to level this thing up so that we track specifically fines. I want to see, you know, demand letter 1 has been sent, demand letter 2 has been sent. This is the amount that's owed. This is what the practice is as far as referring it to the AG, and this is what's been recovered. I don't know. We have to have a more effective system so that we as commission members understand that the time and effort we take to implement our work is being taken seriously from a recovery perspective. We also need to be able to have conversation with the Attorney General's office about the recoveries. But I feel like we don't have the ability to talk about the success or lack thereof of the recoveries if we don't know what the status is, unless there's disagreement.
There's also been
that makes
conversation
sense.
about the process by which we notify and ask for the receipt of these dues. So demand letters being one form, but if we had another way of communicating by text instead of reflecting credit card, you name it. And then is the language, we've talked about it changing to reflect or at least issue to them, you're going to be turning to the AG. What does that letter read currently? Is there a sense of urgency? I don't know what the language is.
It states that you're being given 15 days, for it is referred promptly to the Attorney General for collection.
And to Stephen's point, it'd be a heck of a lot easier if one of the options for payment was to go online and make the payment.
Well, didn't you make that, or no? Yes or no? You made it available online? I remember you did some online work. Online payment versus ACH.
That is saying.
Credit card is still,
We
paying,
have
okay.
not still.
But you can make an ACH payment on our website currently.
No,
That is also.
Still not, okay.
no,
Why is that still pending? That's just directly with the bank, right?
because you have to have a page on your website that leads to that. And for whatever reason, one of the last times, a couple of times ago, we reached back out to the treasurer's office and said, hey, we're still waiting on this. What's going on? They reached out and the company said, yeah, our bad. We haven't done anything. And they still haven't come over and put it into our, onto our website that connects us there.
No,
So,
Could possibly
when you
like.
talk about follow-up, I take responsibility
I
for
really
not.
would like that to be done, in the next 30 days.
I'm
Only because,
Yeah.
we've
Everybody
been
pays.
coming to a resolution on this particular issue now for a year.
Yeah,
The only other thing, Phil, if I may, if Betty Springer, does she still work for the commission?
yes.
Okay. So when we brought Betty on, when you hired Betty, was that effective 1/1 of this year?
Right.
Last year?
Yeah, it was early this year.
One of her primary duties, if I'm remembering correctly, and tell me if I'm wrong, was to get us caught up with
Right.
our AG referrals.
Right.
I think I heard you say to Mr. Kirschner that we were about a year behind.
She is currently, she just sent out some,
More.
15-day notices for about a year ago.
So
Starting next.
that fog is starting to, that jam's starting to hit, okay.
Yes.
But I wanted to make sure that, I'm sure we appreciate her service, that she's moving the needle.
Yeah.
Primarily on the project that you brought her in to do.
Yeah.
So,
And she recently sent out some, and I was gonna say, I talked with two persons yesterday on the phone. And we got a, request for reconsideration on another case.
she works part-time.
Yes, that she sent out.
Did you know?
So it has actually moved the needle, maybe not greatly, but it has moved the needle some.
If we know anything about collections, it's as close as you could be to the time that that bill is issued to asking is your highest probability of getting a return.
Right.
And I mean, bill on the job, if you can't bill on the job, immediately send the bill. Actually, in our very small heating and plumbing business, I just heard my dad say yesterday, your brother didn't bill out on that job and that woman passed away. I said, and that's now our bill. We will have people pass away in a time frame.
Yeah, Phil, if I could, I just want to make sure, I'm new, obviously. It would not be unreasonable, commission member, for us to want that data and information, say a monthly basis. I would say no, right? Because, so I would say, with respect, we talked about this at the last meeting and I asked for this information. And it's my sense that it certainly wasn't provided prior to this meeting. So I would prefer to not retread this path. I would like to just see prior to the next meeting, however you want to document it. If it's a spreadsheet or you guys have something better, that's fine. That has that data, has that information, so that when we want, we can say, hey, what's the status of recoveries? Or it's provided to us on a monthly or quarterly basis. And we can see, here's the list, here's the numbers, here are the letters that have been sent out. This is what's been referred to the Attorney General's office, and here's the level of recovery, so that we have that data and information at a moment's notice. If you guys can implement that, we'll start working on it.
To your point, I think it would be reasonable to do quarterly because of where they are today.
Yeah.
And, you know, expecting should be 30 days on this issue.
We can get a quarterly update,
I
yeah,
think quarterly should be done.
without requesting. I'd like it to just be
Yes.
provided as a matter of. Okay.
So Carl, so I'm clear what you're asking for. So are you asking for what they currently are doing, or are you asking for in addition, a spreadsheet that would show what you were asking for, all the categories, okay? And then probably follow up. So I'm not sure if,
Yeah, I'd love the historical data,
okay,
but I don't want to create a monumental task. So in my mind, we ought to have some sort of a tracking mechanism that includes both what's been done by a column and the total. So that it would be added up, in the Excel spreadsheet, what's been recovered, what's outstanding with itemization. So it would say, Stephen Caraway, $120. Demand letter one's been sent, demand letter two's been sent, not yet referred to the Attorney General's office. It's 90 days old. Here's what's owed. And we have a column that added it up, so that we would have a complete understanding of where things stand. And I think one of the reasons is for our knowledge. Another reason is so that we know what's been sent to the Attorney General's office and we can evaluate efficacy, so that then we can have the conversations. Are these being given due attention? What's the status? Then we know. Because without that knowledge, I think a lot of the concerns in this room might be addressed because some of them just aren't being paid attention to. And so we want to be able to address those. And then maybe we can make some intelligent decisions. It's fair to say, hey, we're not going to send anything over unless it's $1,500 and above. And we won't send the other things out, but we got to have that knowledge. We got to have that information. And to go this long without having a tracking mechanism, let's get it fixed.
A couple quick
That's fair.
questions. So I understand. Current process, we send demand letter one after how many days?
So the first disposition letter is mailed, it's usually the week after the minutes are approved, saying that we can send them.
And the second one gets sent
It's essentially about 45 days out,
after that, okay.
to say we're gonna give you an additional 15.
Okay, you additional 15. But that additional 15 is actually a year plus before the referral letter.
Over, since COVID, it's kind of been pretty close to that. The things have been backlogged as far as getting from that 15-day notice to referring. And so that is something that, with bringing Betty back on, we're working back through that and bringing that time frame back down to where it should be, from the time the disposition letter goes out to employee.
And that's, the AG then would address those things internally before it sends them to special counsel oftentimes in any event. So the first step would be for the AG's office to receive. When they get around to it, they're awfully busy, then they would send demand letters out and then maybe refer it to special counsel. So they would address it internally as well. But again, if we send it over after a year or longer, that doesn't mean on day 366 it will be addressed by the Attorney General.
Of course not. And I mean, I've had some experience with collections. A year out, I mean, you would already be sending that, like, there's like different levels of collection types and different level of recovery payment.
Yeah.
If it's been like over a year, you already went to the level of,
Like the Clark County,
Expect
might not
never
be
to
outraged.
yeah.
It might not be Young Democrats, but it's.
You're sending it to somebody else that they don't even have an organization.
So second question,
You just don't know.
How do you
right?
pay
So
the
what I-
you're-
AG's? Is it just, we pay them per file they work or some combination?
No, they get a 9%, I think it is, from their collections.
9%. So no matter, we send $50, if they never collect it, it's zero.
Right.
If they do, it's 9% across the board, whether it's 50 or 500,000. Okay, so we're not, if we're sending them files, they're not getting paid a fee just for taking the file. Just only, okay.
Percentage only, statutorily provided.
Right, so their incentive to go after a $50 fee is too low on their list.
It is.
Well, I mean, yes and no, because the $50 fee should take minimal time to recover. It's not a year old, right? Those should be low hanging fruit. They're doing the $50 real quick. We're the AG office and it's $50. That's an easy one.
Yeah.
We're a 50 AG's office and we want you to spend 2,000 and less easy to make that payment, right? So,
And it's our job.
agreed, but it's not as straightforward.
It still is our job to understand
Yeah.
what we have, what's been sent.
Yep, we should be
And what
tracking it.
their level of effectiveness.
And we should get reports from them, every so often on where those files sit.
I really believe if we were calling, like there was some call in this SOP and we had a credit card processing capability, even debit, credit, whatever. Over the phone, people are quick to, oh, hey, I missed that. I would love to get it straight with you. And so then we're just over the phone, done.
Text messages, it's sounds.
Yes, so we can have that put together so that we can start tracking, and if there is easy historical data to grab, even from the beginning of the year, I would just think it'd be helpful for our group to understand, where things stand.
And I would like for the meeting minutes to record that my portion of the meeting lasted 35 minutes.
I'd like to assist, I'd like you to add an assist from Mr. Lyle.
For his.
Yes.
I'm looking for always making
We didn't do a clean
Very
sweep.
quick second by night until later.
I swooped in and took one from you, Lyle. I just
You did, we're at it this already.
Should make a motion or a second.
Madam Vice Chair, if I may, the only last point I want to make, the hours late. You had back in the spring a meeting with Prosecuting Attorneys Association regarding some of those I'm sorry, I meant. Yeah, I'm not.
Very direct.
Um, And they essentially, did some pushback. My reaction initially is I don't really care, because it's in the statute, right? And so. That we can refer, correct. I know we haven't necessarily made any movement on that.
Correct.
But what I was gonna ask for today to either, move the ball here or just stop worrying about it, is that over the next few weeks, months, whatever, I wanted to work with you on trying to put some sort of a proposal before this commission, to say this is when the trigger mark is. And I don't know, I think there is some appetite for that here. What that number is, I'm not sure if at all. So just wanted to make sure everybody was okay. If I work with Mr. Richter on that, to bring a proposal back to all of you to say, hey, this is kind of what we're thinking on the taking those at a certain point over to the county prosecuting attorney. Particularly ones that have never acknowledged our existence, and have, a $50,000 plus accrual. The way I look at it is, we're wasting our time, and they have failed to even acknowledge that they have broken the, finance.